So good morning everyone, my name is Lalit Soni and you are watching Drishti IAS. In this live session, we will be discussing Indian Express newspaper. We could not come live yesterday, so we will be discussing all those important articles which were there in the yesterday's newspaper in today's session. Okay, so let's start with our discussion. We'll be starting with the explanation of the practice question which was given to you, and then we'll be moving to the fact of the day. Okay, so we will be discussing one fact, then we will move to the next constitutional amendment. We have seen nearly 5 to 6 constitution amendment in the last session. Now we will be moving further. Okay, now after that we will be discussing these articles. Supreme Court on private property. Now here in this particular front page, here you can see that decades of dispute later, Supreme Court, not all private property can be taken over by the state for common good. Okay, so this judgment has been recited by the Supreme Court, so we will be talking about that. Then moving further, we will be seeing Supreme Court upholds the Madarsa Act. We have discussed in our previous lectures that there is this judgment which has been reserved by the Supreme Court. Supreme Court has given that particular judgment. So here you can say Supreme Court upholds Madarsa UP Madarsa Act strike down provision on the higher degree. We will be seeing why they have strike down the provision on the higher degree, why or what rationale they have given to uphold the Madarsa Act. Okay, so these two things we will be discussing. After that, Kodo millet crisis. In Madhya Pradesh, there is this tiger reserve, that is Bandhavgarh. In Bandhavgarh, there are some elephants. Out of 13 elephants, 10 elephants has died because of some kind of infection. Reports came, and as per that report, there was this Kodo millet poisoning which has happened over there. So we will be seeing why this, what is this kind of poisoning, and what kind of poisoning is that, or what is the factor which is responsible for this. All these things we will be discussing in the article. Other than that, also we will be discussing few more articles. We will be giving some passing references, and for your own read, there are 3 passing references which are there. If you want, you can read them. Okay, so let's start with our discussion. First, we will be seeing the practice question. Which article of the Indian Constitution mentions the Uniform Civil Code, UCC? Okay, article 32, article 39, article 44, article 48. So they are talking about the UCC. This is very basic and common question which has been discussed again and again. When we talk about these questions which are repeating, that means that these articles are important for you. Okay, so you have to be very careful while choosing them. So article 44 is basically talking about UCC. So before moving further, if you have not subscribed the channel, please subscribe it. Have a nice day. Now let's see. So fact of the day. Okay, so there is this application, that is Nabhamitra. Okay, so we have taken this application, and this application was in news because of the cyclone Dana. We have seen that there was this cyclone which has hit Odisha coast. So that cyclone was recently witnessed in the Bay of Bengal area, and that is why this particular application, that is Nabhamitra application, was in news. So let's see what this application was and what was its use. Okay, it helped fishermen in the sea during cyclone Dana using the vessel's communication and the support system. Now obviously when these situations like cyclones are there, there are various fishermen which are already inside the sea overseas. So for their communication, we have this system, that is vessel communication and the support system. Now it allows real-time tracking of the vessel position, course and speed, and helping fishermen return safely to the shore during the adverse weather conditions. Okay, so that is basically for the navigation. Other than that, for detection as well. Okay, so there will be GPS etc., which will be you can say set up inside the vessel, and they can locate the position of the vessel, speed of the vessel, direction of the vessel, and accordingly they can directly locate the vessel, and then they can help them bring back to the source. Okay, now it is an initiative by the Ministry of Fisheries, Animal Husbandry and Dairying, featuring indigenous transponder technology. Okay, so you can say this is an initiative of Ministry of Fisheries, Animal Husbandry and Dairying. Okay, it was developed by the Indian Space Research Organization ISRO and is being implemented through New Space India Limited, that is NSIL, that is basically a commercial arm of ISRO. Okay, so all the commercial operations, they are basically handled by this NSIL, and this is an initiative of Ministry of Fisheries, Animal Husbandry and Dairying. Okay, so you can remember all these things. Now we can move further to the next thing, that is basically your constitutional amendment. Now we have seen few constitution amendments, and now next important is 18th amendment. Okay, so 18th amendment that was done in 1966. Now it made it clear that the power of parliament to form a new state also includes power to form a new states or union territory by uniting a part of state or union territory to another state or union territory. Now when we are talking about this particular provision which is given over here, that means that when we talk about the power of parliament to create a new state, that includes that parliament can unite the existing, let's say this is one state, this is basically a union territory, they can actually merge them and form a new state. Okay, so it is clear that the power of parliament to form a new state also includes power to form a new state or union territory by uniting a part of state or a union territory to another state or union territory. So basically say they can go for the internal reorganization. Okay, so that is the simplest meaning, that they can go for the internal reorganization. So using this particular amendment, they have created new states, namely Punjab and Haryana. Okay, now we can go further and start with our today's discussion, that is with respect to the Supreme Court's judgment. Okay, so now let's see over here. Decades of dispute later, Supreme Court said that not all property can be taken over by the state for common good. Now there is this article 39B. Okay, now this 39B is the article which is given in the constitution, that is basically part of your DPSP, that is you can say that is a directive which has been given by constitution to the state. Okay, now article 39 has a particular phrase, that is material resources. Okay, material resources. Now the thing is, what kind of resources? Okay, now they have said that earlier there was this you can say stand which has been taken by the Supreme Court, that says that resources include both public as well as private. So government for the purpose of common good can acquire the private property as well, private resources as well. But now in this particular judgment, they have said that not all kind of private property can be acquired by the state. Okay, because the thing is, earlier whatever judgment which has been given, we will be talking about that judgment as well. So at that point of time, judges has taken a particular kind of decision, or you can say particular stand with respect to a particular ideology. Okay, and the current bench has said that we cannot rely on one ideology, because we have a democracy in the country and we will choose the government, and government will according to the time. Since we know that our constitution is also an organic document, our form of governments are dynamic. So basically we are saying that since we have democracy, with respect to the time, they will change the nature of economy as well. Okay, now if we talk about taking the resources, that all the private resources can be utilized by the state or acquired by the state, that means that you are moving more towards the communism kind of thing. Okay, now when we are talking about the current state of economy, which is a mixed economy. Okay, so considering that Supreme Court has given a judgment, let's see what they have said. 8:1 majority view draw distinction between the individual and the community. Okay, they have said that individual property is different from the community property. Okay, when we are talking about the community property, we can use that for the common good. Individual property, there is some part of it can be used for the common good, and not all the property can be acquired by the state. Okay, so let's see. India flags an arc of economic progress. Here you can say, in a landmark ruling that has implications on the citizens' right to hold property, a 9th judgment of the Supreme Court on Tuesday ruled that not all private property can be deemed as material resource of the community. Now this term which I told you that is mentioned in the article 39B, material resource of community. Okay, now they have said that the word which is given over here, or the phrase which is given over here, that has a meaning over here. When previous judgment which is saying that all the private property can be acquired by the state, that means that they have only focused on the resource. Okay, they did not focus on the other terms, that is material and the community. When we talk about the resource of the community, they did not say that the resource of the state. If that is the resource of the state, that means that will be the public property only. They did not use the word only resource, just resource. They could have written only material resources. Okay, in that case you can say that both state as well as private property could be there, but they have used the term material resources of the community. Okay, so they have differentiated between individual, state and community over here, and that is why the you can say court has taken cognizance of this particular word over here. So here you can see, not all the private property can be deemed material resource of the community for redistribution under Article 39B of the Constitution. The phrase material resource in Article 39B of the Constitution may include privately owned resources, not all privately owned resources which fall within the ambit of this phrase. Okay, so basically they are saying that there can be some private property which can be acquired for the common good, but not all the private property is subsumed under the term that is material resource of the community. Now let's see what does that mean. Now there are various cases in which this particular question has been discussed. There was this case in 1977. That name of the case was Karnataka, state of Karnataka versus Sri Ranganath Reddy. This was the name of the case, Karnataka versus Sri Ranganath Reddy. In this particular case, there is this justice that is V.R. Krishna Iyer. He has given one interpretation. We will be talking about that. Now let's see. The ruling in the constitutional reference essentially undoes the several decades of the Supreme Court's jurisprudence on the issue that was given in the 1977. Whatever you can say judgment which has been given in 1977, after that was reiterated in 1982, I guess. Okay, so there was this jurisprudence which has been established by these two cases, but now they have undone that, or they have actually you can say changed that. Okay, so now let's see. Here you can say, a line of judgment holding that both public and the private resources will fall within the ambit of material resource of the community under Article 39B. In this particular case, that is V.R. Krishna Iyer has said in state of Karnataka versus Sri Ranganath Reddy 1977, and that particular thing, they have said that all the private property will also be included under that particular you can say term, that is material resources of the community. Okay, so in 1977 they have said that all private property can also be acquired by the state if the need be. Okay, now then coming to the 1982 judgment, there was this 5-judge constitution bench which has said that they have, the name of the case is Sanjeev Coke Manufacturing Company versus Bharat Coking Coal. They have affirmed the Justice Iyer's you can say instance which has been given in 1977. So in 1982 also this particular thing was reiterated, saying that all the private property will be acquired, can be acquired by the state if the need be for the common good. Okay, now moving further, Justice Iyer at that point of time, what was the situation, what was the you can say rationale behind that has been discussed over here. So let's see. Justice Iyer cast to net wide, holding that all resources which meet material needs are covered by the phrase, and any attempt by the government to nationalize these resources would be within the scope of Article 39B. That basically they are saying that all kind of resources, including private, public, community, all kind of resources can be acquired by the state if the need be under Article 39B of the Constitution. Okay, then part 4 of the Constitution, why we are saying that can be within the scope of 39B. 39B is basically part of your DPSPs. Now DPSPs are not enforceable itself. For that you need to have a law. Okay, if state makes a law which is implementing a DPSP, that law will prevail. Okay, so here you can see part 4 of the Constitution, the directive principle of the state policy, DPSP, Article 39B places an obligation on the state to create policy towards securing the ownership and the control of the material resources of the community. Here the word is material resources of the community are so distributed as best to subserve the common good. Okay, basically they are talking about the just optimum redistribution of the resources. Okay, and they have said that public property can also be included in that. Now DPSPs are guiding principle of the law, or you can say they are guiding principle for the states, guiding principle of the enactment of the law, but are not directly enforceable in any court of law. As I told you, for that to be enforceable you need to have a law. Okay, now to declare Article 39B includes distribution of all private resources amounting to endorsing a particular economic ideology and the structure of the economy. Now in this particular judgment, the you can say judges has said that that particular you can say stand which has been taken by the Justice Iyer in, you can say, that Karnataka case. So basically that was based on a particular ideology. Okay, so that is what had been written over here, and that was influenced by a particular school of economic thought. Now, which prioritized the acquisition of private property by the state is beneficial for the nation. So basically that school of the economic thought which is saying that the property can be acquired by the state, okay, for the common good. Now it is concurred with the majority view on what constitutes the material resources of the community. Now they have seen that over here they have make a distinction between the word that is material resources and of the community. Okay, so they have said that it is not the material resources itself. There are distinction which has been created by the constitution, because constitution wanted that kind of distinction to happen. Okay, now here you can see here need for a flexible interpretation. Neither can there be a canonization of the socialist policy followed by the state, nor can the principle akin to laissez-faire economic be ignored at the time when the state is following them. Now they are saying that particular judgment was you can say influenced by a particular thought of economy or this particular school of economy, but right now they are saying that we cannot actually go on the one side. We cannot just focus on the socialist principle, we cannot just focus on the laissez-faire, we cannot ignore the laissez-faire, because right now we are propagating this laissez-faire because we are going for the mixed kind of economy in India. So we have some you can say sectors wherein we are having this market economy, or you can say the laissez-faire market is free to you can say free to be there. So considering that, they are saying that we cannot be on the extreme ends. Okay, let's see. One part is your socialist economy or communist economy, okay, which is saying that all the resources will be owned by the state. Okay, coming to the next one here, that is your laissez-faire or you can say the market economy, which is saying that markets are free, they will be working on their own demands and supply rule. Okay, now India is having a mixed economy somewhere over here. In some sections we are having, some sectors we are having laissez-faire, in some sectors state is having the monopoly. Okay, so we cannot go on one end, we are having a mixed economy, and now it is for the government to decide the policy. Okay, now moving further, here you can see disagreed with the majority view on the interpretation of the Justice Krishna Iyer and the Chinnappa Reddy. The observation of the judges in those decisions would not call any critique in the present times, neither it is justified or nor warranted. Now as I told you, this judgment is 8:1. Okay, now in the 8:1 judgment, there is one judge who is dissenting, which is giving an totally an opposite interpretation. They are saying that we should stick with the, you can say, 1977 and 82's you can say judgments. And but there is one another judge which is having a partial, you can say, opinion in which they have said that you can say this particular thing, they have taken a, you can say, mixed kind of approach over there. So let's see what is that. Dissenting judgment in Justice Dhulia, they have said that the broad and inclusive meaning given to the material resource of the community by the Justice Iyer and Justice Reddy has stood in the good stead and lost none of the relevance and jurisprudence value, nor has it lost the audience which has the which has appreciated those values. So basically they are saying that whatever judgment which has been given by the Justice Iyer and the, you can say, Justice Reddy, that should be, you can say, stick to. Okay, now interpreting Article 39B to place all private property within the ambit of the material resources of the community only satisfies one of the three requirements. Now coming to the phrase was material resources of community. Now the judgment which was given in 1977, that judgment only focused on this particular thing, that is resources. Okay, and they have ignored the word material and the community. So let's see. So here they have said that they only satisfy one of the three requirements, that the goods in the question must be a resource. So that is one thing. It ignores the qualifiers that must be material and community. Okay, so that has been ignored. The word of the community must be understood as a distinct from the individual. So that is what they are saying, that it should be distinct from the individual. So they are making a distinction between the community, individual and the state. Okay, moving further, if Article 39B was meant to include all resources, if the idea behind Article 39B was to include all the resources, they would just have written the you can say use the word the ownership and the control of the resources. Okay, so they would have just stopped over here, material resources, that's it. Okay, they have include of community, that means there is some kind of distinction which was made. Okay, now it would state that the ownership and the control of the resources is so disputed and best to subserve the common good. Now if the provision was to exclude private property altogether, so they would have gone for the material resource of the state. Okay, now if they wanted to, you can say, remove the private property altogether out of the ambit of article 39b, they would have just written, in place of the material resource of community, they would have written material resource of the state. But they have written multiple you can say material resources of the community. That means that there is some part of private property that will also be subsumed under article 39b. So that is what has been given over here. Okay, now they have given or cited Dr. B.R. Ambedkar's view over here, that is, if the constitution laid down a particular form of economic and the social organization, it would amount to taking away the liberty of people to decide the social organization which they wish to live in. Okay, so basically they are saying that our constitution does not specify a kind of economic system which we would follow. Okay, they have said that if we decide now, that means that we are taking away the liberty of the people from the future generation to decide for themselves. Okay, right now we are having a democratic government. That means that people are deciding for themselves, and when they are selecting their government, the government has a mandate and government will decide on the economic policy depending on the time and necessities. Okay, so when we talk about the before 1991 we have a closed economy, and after 1991 we had a, you can say, open economy, wherein we have gone for the liberalization, privatization, and the you can say globalization. So that means that we had the liberty to change the stance on the economy. Okay, so that is what has been given in this article. Now we can move further to the next one. Okay. Why the Supreme Court upheld the constitutional validity of the UP Madarsa Act 2004. Now UP Madarsa Act, what was the issue? In you can say Uttar Pradesh, there are various madrasas which are controlled by this or regulated by this act, that is UP Madarsa Act. Okay, now the validity of this particular act has been challenged in the Allahabad High Court, and Allahabad High Court actually struck down this act, saying that it is against the basic feature of the secularism in our Indian constitution. So they have struck down the particular act. Now appeal goes to the Supreme Court, and Supreme Court has decided on the matter, and Supreme Court has upheld the UP Madarsa Act, but they have struck down a particular provision. Last time when we discussed that, we have seen that what Supreme Court's observation was. Supreme Court therein has said that striking the act altogether, it will not serve any kind of purpose. So whatever discrepancies are there, you should remove them. Okay, so they upheld the act and they have removed the discrepancies. Okay, so let's see what was the issue and what has been done over here. Now, the Supreme Court on Tuesday upheld the constitutional validity of the Uttar Pradesh Board of Madarsa Education Act 2004, that is Madarsa Act, bearing the provisions relating to the higher education. Okay, they have actually removed these particular provisions with respect to the higher education. We will see why. Now that has overruled the Allahabad High Court's earlier ruling, which struck down the entire act of violating the principle of secularism. Okay. Moving further, what is the Madarsa Act? Now, when we talk about this Madarsa, these are basically minority institutions, okay, and which has been established under article, you can say fundamental rights, which are there, article 28, 29 we have, okay. Now, let's see. Madarsa provided both religious as well as the secular education. So, when we talk about the religious education, so they are basically talking about the Islamic tenets. Islamic tenets and the practices which are basically used in the religion, okay, and they are also providing you the mainstream secular curriculums or the mainstream secular education, okay. So when we talk about madrasas, they are, you know, giving both kind of education, religious as well as the secular education. Most of the madrasas are basically used, you know, following the NCERT curriculum in the secular sphere, okay. And other than that, we have this Madarsa Act which is regulating that. You can say the Madarsa Act provides a legal framework for these institutions in UP. It has established Uttar Pradesh Board of Madarsa Education, that is the board which is being referred, okay, the which prepares and prescribes the course material, okay. So curriculum basically is decided by the board over here, and it conducts all kind of examination, and it has also has the power. Power has also been given to the state government to create certain rule to regulate the madrasa education. Now that rules has been given in the Madarsa Act 2004. Now, why Allahabad High Court has quashed the act? So, Allahabad High Court has seen that this particular act is violating the basic structure, that is basically your secularism is part of the basic structure. So, let's see. It has violated the basic structure of the constitution and it is against the principle of secularism in Keshwanand Bharti versus State of Kerala. Now, this is 1973's landmark judgment, which is there, Keshwanand Bharti, in which we have actually coined the term basic structure. Okay. Now, Supreme Court will decide what is the basic structure on the case by case basis. So, here you can say the Keshwanand Bharti versus State of Kerala 1973. The Supreme Court has held that the Parliament cannot alter the Constitution's basic structure, and in S.R. Bommai judgment, okay, S.R. Bommai versus Union of India 1994, they have ruled that the secularism is part of the basic structure of the Constitution. Okay. Now, these two becomes highly important for you from this point of view. Okay. Moving further, High Court has said that the act is made it compulsory for the student to study Islam and more modern subjects were made optional. Now, in the Madarsa education, there are two you can say aspects over here. One is your Islamic education or religious education, and second is your modern education. Now, they have made Islamic education compulsory and modern education has become optional over here. And considering that, you know that we have this even part of the DPSP, our fundamental duties, and even a fundamental right is there, that is the right to education. In that, modern education or the modern technological education is part of this. Okay. So, now that is being made optional, and that is why you can say that there is some kind of discrimination which is also happening against the child who is getting a modern education and someone who is not. Okay. So, that is one thing. Second thing is, this is against the secularism because you have made it compulsory. Now, this should be made, you can say it should be there should be a provisions which are saying that as per the arguments, which is saying that this should also be made compulsory, you can say optional, because if one want to you can say talk about or read about religion, that is the part of his own choice. Okay. So, that is why the you can say court has said that it is against the basic structure, or you can say the secularism of the Constitution. Okay. The act made it compulsory for the students to study Islam and made more modern subjects were made optional. State cannot discriminate by providing the education based on the religion. On the basis of this, they have actually struck down this particular act. Okay. Now, moving further, act violated the right to free and compulsory education under Article 21A of the Constitution by denying quality education in the modern subjects. Okay, as I told you, that is also a fundamental right, quality education in the modern subjects. Now, board is powered to give, you can say, degrees like Fazil and Kamil. Okay, Fazil, Kamil. These are basically, you can say, your UG degree. This is the PG degree which has been given by the Madarsas. Madarsas give these you can say degrees, but the problem is that that is against the you can say law. We have UGC, University Grant Commission, and as per section 9, only the institutions which are affiliated by the UGC or which are having a status of universities, that can only give you these degrees. So, ultimately these degrees are not valid, these are not recognized by the UGC. So, that is why that is also one concern over here, and on the basis of which Allahabad High Court has struck down this particular act. Okay. Now, moving further, why did Supreme Court uphold the act? Now, Supreme Court has taken you can say observation over here in this particular case. They have said that basic structure test is not needed. Supreme Court has said that in the cases wherein the constitution amendment has been made, in those cases you can go for the basic structure doctrine, or you can say test of the basic structure, but not in an ordinary law. Okay. So, that is what has been written over here. Constitutional amendments are tested against the basic structure doctrine and not in not an ordinary legislation. There was this incident which has been given, Indira Gandhi versus Raj Narayan 1975, which pertained to an amendment to Representation of the People's Act 1951 that enacted to reverse the Allahabad High Court's ruling to disqualify Indira from participating in election. Now, this was also an ordinary law. That is why the constitutional, or you can say the basic structure doctrines test is not being used over here. Second thing is that state can regulate. In this particular instance, when we talk about the Madarsa Act, the Supreme Court said a law to be struck down for violating the principle of secularism, it must be traced to express articles of the constitution. Okay, so again, if there is a constitutional amendment, then you can go for this particular test. Okay, moving further, the state can regulate the madrasas. Now we have this, you can say, fundamental right that minority institutions will have their own administration, but state can also go for the, you can say, administration, you can say, regulation of these particular institution in some cases. Okay, so here you can say, so long as the regulation is reasonable and rational, state can regulate aspects of the education in minority institution without violating their right to handle the administration. The Madarsa Act does without depriving the education institution of their minority characters. Okay, so that education institute still has the characters that is basically of a minority institution. Okay, despite that, state has rights to go for the regulation. Okay, entry 25 of the concurrent list, which is basically related to the education, that state and center both has power to make law with respect to the education. Okay, now broadest meaning has been taken, include institutions that are provided religious education. Now in this particular term, when we are talking about the education, in that the religious education or the, you know, institutes which are of the minority in nature, they are also being included over here. Now right to education and minority institution. Now article there was this case in 2014 which has challenged that the right to education or the fundamental right which has been made over here. Supreme Court heard a challenge to the constitutional amendment, that is article 21A. The court held that the right of children to free and compulsory education, that is RTE Act 2006, must not apply to the minority institutions as it may destroy their minority characters. Now when we are talking about right to free and you can say modern education, that means that every person should be allowed to study in a institution. Okay, now if this law is being applied to the minority institutions as well, that means that a person who, let's say, minority institution is there that is related to the Islamic you can say religious education, and now there is this particular person who is basically Christian and he wants to get admissions over here, so that can be a problematic thing, because ultimately that might destroy the minority characteristics, and that is why the minority institutions has been kept out of the RTE Act of 2006. Okay, now considering that, the court over here has said that there is no conflict between these two things because they are separate things. Okay, so here you can say Supreme Court has erred by striking down the law for violating the right to education. The court has also stated that the minority institutions such as madrasas have right to provide religious education and handle their own administration under Article 30. Okay, Article 30 is basically related to your you can say regulation of the minority institutions. Okay, now moving further over here, why did the Supreme Court strike down the higher education provisions of the Act? As I told you, these degrees are being given, Fazil and Kamil. So these degrees are not being recognized by the UGC because that is violative of the section 9 of the UGC, which is saying that there are only few institutions which are affiliated or given power to grant these degrees that will be valid. Okay, so section 9, which allows the board to prescribe coursework, conduct exam and the grant degrees to those who has finished the Kamil and the Fazil, is contrary to the UGC Act. Okay, sorry, this is section 70 and this is section 9. This is section 9, which is basically saying that the board, the madrasa boards which are there, which can give such degrees. Okay, now here this is against the section 22 of the UGC Act. Sorry, I don't know what I'm doing. So this is section 22. Okay, sorry. So section 22 of the UGC Act, only universities which have been established under the central or the state act or have been deemed to be university by the UGC can grant degrees, and therefore Supreme Court struck down the section 9 of the Madarsa Act. So this section 9 of the Madarsa Act has been struck down. They will no longer be authorized to give degrees like Fazil and Kamil, or you can say undergraduate and the postgraduate degrees, because these are not recognized by the UGC. So they have upheld the law. They have only, you can say, let go of this particular provision that is given under section 9 of the you can say this particular act. Okay, so that is about the Madarsa Act. Now we can move further to the next one. US poll Chinese stimulus triggers that outweighed the domestic factors in the FBI sell-off. In the last discussion also we have said that FBI are basically outflowing from India. Okay, and why is that happening? There are 2-3 factors over here. Okay, one is the domestic trigger. Domestic trigger because when we are talking about the demand, okay, and when we are talking about the domestic you can say corporate sector, So they are not performing well recently. So that is one thing, because there is this sluggish growth which is there in the corporate, and because of which also we are seeing you can say downfall in the FPI. Okay, so sluggish corporate commentary and the potential earnings cut, which is leading to the re-rating of the stock valuation. Because corporate is not performing, that means that your stock valuation is declining. Stock valuation is declining, that means that our stocks, our equities, our you can say investments are not basically you can say any appealing anymore or attractive anymore, and that is why these you can say FPIs are moving outside India. That is one thing. Second is the US election linked volatility and the Fed trajectory. In USA we are witnessing that elections are going on the basis of these elections they will decide the fate of the markets over there, and that is why also you can say the US's investor is quite skeptical right now. So that is one thing. Then moving to the next one, that is the big China factor. As I told you, India's corporate sector is facing sluggish growth, and because of which our stock valuation are declining. But the thing is, in China they are going for the stimulus in the economy. They are giving stimulus, they are giving incentives, they are actually injecting various capital or liquidity in the markets. Okay, because of which their investments are lucrative, their investments are basically appealing right now. So most of the foreign investments which are getting outside India, they are moving towards China. We have discussed all these things earlier, so I'm not going into details of this, but just know that India is facing a situation wherein our FPI, foreign portfolio investments, they are going out. So there is this outflow, and China is seeing an inflow of the FPIs. Okay, so that is about this article. You can go through this. Moving further, we have this Bandhavgarh jumbo you can say deaths which are there. Bandhavgarh jumbo deaths. Jumbo is the term which generally is used for the elephants. Okay, toxicology reports are saying that it is due to the fungus in the kodo millets. Now you know that millet is basically a tropical or subtropical crop, you can say. And this is grown in the arid and semi-arid region. So in the areas like Rajasthan, Gujarat, Maharashtra, Andhra Pradesh, Tamil Nadu, we will be seeing that there is this crop which is available, that is millet. If we talk about this kodo millets, this is one kind of, or you can say this is one variety of millets, and this is also prominently it is grown in Madhya Pradesh. Okay, and after that in the nearby areas like Gujarat, Maharashtra, and Karnataka, Andhra Pradesh also it has the you can say cultivation. But right now when we are talking about this kodo is a crop, kodo millet, which is a crop of the arid or semi-arid climate. And if because of some kind of environmental factors there is moisture availability in the area, okay, because of which there can be a fungus development or fungi development which can happen, and because of this fungi development there is this infection, and this infection is basically you can say lead to some kind of mycotoxins which will be released, and these mycotoxins are basically not good for the health of those who are consuming it. And in this particular incident there are some in Bandhavgarh Tiger Reserve there is a herd of 13 elephants, and out of which 10 has consumed that and they have died. Okay, so that is been cited as a reason that there was this kodo you can say poisoning which has happened. Okay, so for that there are 2-3 things which is important. One, you have to remember all the you can say requirements for the millet cultivations. Second thing is what is kodo millet. Third thing is where this is found in India. So we have seen that millet is basically a tropical and a subtropical you can say crop, and it is found in the you can say arid and the semi-arid areas. Temperature requirement is somewhere around 27 to 32 degrees Celsius. If we talk about rainfall, it can be cultivated in a less rainfall area. And if we talk about the you can say richness of the soil, it can be grown in the poor soil as well. Okay, now talking about kodo millet, it is a variety of the you can say millets which is there, and it is prominently found in Madhya Pradesh. Other than that there are areas like Karnataka, Andhra Pradesh, Tamil Nadu, Gujarat also they can we can see the cultivation of that. Okay, recently in the Bandhavgarh National Park and the Tiger Reserve, we have seen that there are 10 elephants which has died, and because of the report which is been given, it is said that it is because of the kodo toxicity, or you can say there was this fungi which is there, and because of which there is this mycotoxin which has been you can say made over here because of the fungi infections, and that mycotoxin is CPA, that is cyclopiazoic acid. Cyclopiazoic acid, this is the compound, or you can say this is the, you can say, toxin which has led to the death of 10 elephants over here. You can go through this article which we have already covered over here. Here you can say cyclopiazoic acid which has been mentioned over here. We have talked about the kodo. Because of this toxicity, because of this particular acid, that is CPA, there can be multiple organ failures in the animals, that is, that can actually lead to liver, kidney, spleen, heart, lungs and stomach, and the intestine, you can say, contents of the elephants, they will actually get affected. Okay, report is saying that this is because of the codotoxicity and not because of some kind of intentional poison which has been given to the elephants. Okay, considering that, it has been advised that the area should be demarcated, and if there is some kind of fungus which has been developed over here, so that should be you can say animals should not be allowed in that particular area. So area should be surveyed around the Bandhavgarh Tiger Reserve. So that is about the news. Bandhavgarh is located somewhere over here in Madhya Pradesh, so you can remember that. Okay, so that is Bandhavgarh. Cyclopiazoic acid, CPA, mycotoxins. We have also talked about the kodo millet, etc. Okay, now we can move further to the next article, which is basically MiG-29 fighter jet. There was this crash which has happened in Agra. There was no casualty. Pilots has actually you can say ejected from the MiG. Okay, it is a twin engine multi-role fighter jet developed by the Soviet Russia in 1970s. Now India and Russia are having partnership in this MiG-29. Okay, so MiG series is the, you can say, MiG-21 is there, MiG-26 was there, MiG-29 is there. Okay, so that is there with cooperation with the Russia. Okay, dangerously poor air quality, Lahore schools shut for a week. This was news from yesterday's newspaper. Lahore has witnessed, you can see, the poorest, you can say, air quality which was there. Lahore is there in Punjab, which is there in Pakistan. India also has Punjab. Some part of the, when we talk about pre-independence, we had a Punjab which was there province, and most of the part is there in Pakistan. Some of part is there in India. Okay, so that is there. So there was this green lockdown which has been imposed in Pakistan. The air quality index in Lahore exceeded over 1000 on the weekends, record high in Pakistan. Okay, and Pakistan is blaming India for this pollution. So that is one thing. Moving further, next we have pro-Khalistani man targets temple in Canada, and we don't have to go into details of all these things because we have already seen this will affect the India-Canada relations. And you know that there was this issue of the killings of the you can say Khalistani separatist Hardeep Singh Nijjar. Okay, because of which also there was various ups and downs in the India-Canada relations. Okay, there was this allegation which were made against the Indian government, and Indian government has said that these are absurd and baseless. We have discussed all these things earlier. You can go and focus on the India-Canada relations. Okay, now moving further. Here, Japan successfully launches defense satellite carried by a new flagship H3 rocket. Japan has launched a defense satellite. Now, you know that Japan is going for, you can say, enhancement of the defense technology, etc. So that is there. They have actually launched a satellite, and the name of the satellite is Kiramaki number 3. Okay, and that has been you can say launched by H3 rocket. Okay, so I hope that is clear. Now moving further here, Army successfully conducts patrolling of the key points in the eastern Ladakh and the Depsang sector. These are the areas which are disputed. Recently there was this agreement with respect to the patrolling in the legacy points. That is, one is your Depsang. This is the Depsang area, and second was Demchok. This is the Demchok area. Okay, so Army has conducted a patrolling over there. So please remember all these points. That is Daulat Beg Oldie, Depsang Plains, Galwan. Then we have Gogra Hot Springs, we have Pangong So Lake, we have Chusul, we have Demchok. These are the area which you should remember, and this is the area which is Aksai Chin, which is right now under the de facto control of China, and it is an illegal control. So that is about it. Now these are the passing references I wanted to tell you. Bihar Kokila Sharda Sinha passes away at 72. She was famous for her folk songs. Okay, recently you know that we have Chhat Puja, and she is famous for the songs which are being played during the Chhat Puja. Okay, so you can go, remember this particular name, that is Sharda Sinha. Okay, she used to sing in Maithili, Bhojpuri, Magahi, Sanskrit and Hindi. Okay, now moving further, Indonesia tribe language passed down orally for centuries get a script. There are various languages which are being spoken in Indonesia, okay, and they do not have their own script, okay, so they are using the Korean script to actually learn these languages, okay. So that language name is Shia or Sia, and they are using the you can say script that is Hangul. Okay, so this is a Korean script which is they are using for you can say activities in the school and classrooms. Indonesian tribe language passes down orally for centuries gets a script that is Korean. Now they will be using Korean script for that. Indonesia is the country which is having the largest, second largest language you can say diversity. The largest one is there in Papua New Guinea. Okay, so Papua New Guinea is the world's you can say a country which is having the largest diversities of the languages, okay, and Indonesia is the second one. Indonesia has more than 700 native languages over there, okay. There are various languages which used to, when we are talking about the Shia, earlier Arabic was used for this particular language, but it was not very complementary because of the, you can say it does not have the similarity, and that is why they are using Hangul as a language, and that is a part of a Korean script. Okay, so that is there. You can go through this particular article. There are name of two islands which has been mentioned over here. You can see Shia, an indigenous language that has no script, survived orally for centuries in Indonesia, spoken by nearly 93,000 people in the Shia tribe on the Buton island. Okay, so this is a Buton island, and second is the peninsula of Sulawesi island. Okay, so these two things are there which you can go and search on internet and keep it in your notes. Okay, so that is all about today's discussion. In the end, we have this question, that is Bandhavgarh National Park is located in which of the Indian states? Rajasthan, Madhya Pradesh, Maharashtra and Karnataka. So you can attempt this question and answer to me in the comment box. With that, I would like to take your leave. I'll see you in the next episode. Till then, have a good day. Thank you, and please subscribe the channel.